Hello and welcome to Wednesday webinar. Nothing interesting in the background tonight. It's too wet outside. Tonight I'd like to talk about the issues surrounding whose name to put on the title of an investment property. Now, companies are never used because a company does not qualify for the 50% capital gains tax discount. Sometimes this can be a bit confusing because the trustee of a trust is a company, so I'll explain what the trustee is. Only sane people over 18 years of age and a company can enter into contracts. Unlike trusts, companies and sane adults are legal entities. A trust needs a legal entity to act for it. In other words, it needs a trustee. If a person acts as trustee, then they can be held personally responsible. This is why most trustees are companies, which you can control by being the shareholder and the director. It puts a corporate veil between you and the trust. Nevertheless, the property is owned by the trust. If a capital gain is distributed from a trust to an individual beneficiary, that beneficiary is entitled to the 50% CGT discount if the trust would have qualified for the 50% CGT discount. For example, the property has been held in the trust for more than 12 months. So now let's look at the idea of holding the property in a trust. There are basically two types of trusts you need to consider: a fixed or unit trust and a discretionary trust. A hybrid trust tries to combine some of these features of both the fixed and discretionary trust, but it is just not effective for tax purposes and can really cause you some grief, so leave hybrid trusts alone. In a fixed or unit trust, you have a defined right to a share of the profit. This means you can borrow to buy the units in the trust. The trust then uses the cash to buy the rental property. Because there is no interest charged to the trust, there is a profit that can be distributed to you into your personal tax return. And that is where you claim the interest on the loan that you took out to buy those units in the first place. This gives you an opportunity to negatively gear, yet hold the property in the trust. So this will give you asset protection from anything to do with the house, but not the other direction, because you own those units. You've got a fixed right to the trust through those units, and your creditors are entitled to take those units from you. Further, as you have a fixed right to the income of the trust, you cannot transfer the income stream to someone else without triggering a capital gains tax event. And that would be on the increase in the value of the property, not just on the original purchase price. In most cases, this arrangement is not much better than owning the property in your own name, but is more costly to set up and maintain. A discretionary trust allows you to distribute the profits each year to whichever family member suits you for tax purposes. The catch is you will not be able to negatively gear the property in your personal tax return because you do not have a fixed entitlement to the profit. This means that the borrowing for the property has to either be in the trust's name or in your name, but on lent to the trust for the same interest rate. If the property is negatively geared, the loss is locked in. So the trust can only offset that loss against future income or income you can distribute to that trust from another trust. This is sometimes a good thing if the losses were going to be wasted in your name. For example, you're on a very low income. A discretionary trust is worth considering when a property is positively geared. A discretionary trust might also be useful even if the property is negatively geared, if you have a low income now and will be in a high tax bracket when you sell or when it becomes positively geared. If you have a good income and the property is going to be negatively geared for considerable time and you don't intend selling it until you retire, then you may well consider holding the property in your own name. This, of course, doesn't give you any asset protection, so give some thought to how likely you are to be sued. If you ever want to cover the property with your capital gains tax main residence exemption, then you will have to hold the property in yours or your spouse's name. Now, of course, there are many little quirks that need to be considered in light of your particular circumstances, and I haven't included self-managed super funds in this discussion. That's for another Wednesday webinar. But I hope that this gives you some clarity on the trust versus personal names argument. You will still need to consult your accountant before you decide the name to go on the title deed. Thank you for staying through to the end. Hope to see you next week.